In this lecture, we shall conduct an overview of the constitutional law of Ghana. An overview of the constitutional law of Ghana. The first topic we have to deal with is Introduction to Constitutional Law and Constitutions. Introduction to Constitutional Law and Constitutions. Now, if you finish studying this topic, remember that as far as the definition of constitution is concerned, you have to remember that there are two theoretical standpoints or two broad definitions of a constitution. For the two definitions of a constitution, you can rely on Munro, M-U-N-R-O, because he has given two definitions of a constitution. He gives us the broad definition and he gives us the narrow definition. For the broad definition, we have the body of rules, principles, practices, and attitudes relating to the creation and implementation of the system of government. That is, the structure, functions, and powers of the organs or centers of power for the management of the public affairs of the state. So basically, it means that for the broad definition of a constitution, we are essentially referring to the body of rules, principles, practices, and attitudes relating to the creation, implementation of the system of government. That is as far as the broad definition of a constitution is concerned. And you will see this definition having been referenced on page 2 of the book titled The Handbook of the Constitutional Law of Ghana and His History, authored by Sir Kofi Kumadu. Remember, like I mentioned, Monroe gives us two definitions of a constitution, and what I have just mentioned is the broad definition. Then we also have the narrow definition of constitution, and this is how Monroe gives the narrow definition of a constitution, which you see on page 3 of Sir Kofi Kumado's book. Remember that for the narrow definition of a constitution, we are referring to a document or a series of documents in which the rules or laws are embodied. So you see, for the narrow definition, the focus is on a document or series of documents. So when I say a document, I'm referring to an example, that is the 1992 Constitution of Ghana. Then if you talk about series of documents, an example can be the 1957 Independence Constitution of Ghana or the Gettysburg Constitution of the Gold Coast. So remember that for the definitions of constitution, we have the broad definition and we have the narrow definition. For the broad definition, we are referring to Munro, we are referring to the body of rules, principles, practices, and attitudes relating to the creation and implementation of the system of government. But for the narrow definition, we are referring to a document or a series of documents that in which the rules of or laws are embodied. And if you want cases that have explained, you can use to explain the broad definition of a constitution. At least you should not forget the case of MPP and Attorney General, the 31st December case. And don't forget the case of Tufor and Attorney General. So you see, Tufor and Attorney General, you remember in this case, the justice that gave the decision of this particular court. So remember in this particular case, SOWA JSC. You remember he actually defined the constitution as a document having a letter and also having a spirit. You remember? So in Tufor and Attorney General, if you want to explain the broad definition of a constitution, we can rely on Tufor and Attorney General, because that is where we heard the statement from SOWA JSC that a constitution such as ours is not an ordinary act of parliament. It embodies the will of a people. It also mirrors their history. Account therefore needs to be taken of it. As a landmark in the people's search for progress, it contains within it their aspirations and their hopes for a better and a fuller life. Remember, in this case of Tufor and Attorney General, SOWA GSC mentioned that a written constitution such as ours is not an ordinary act of parliament. It embodies the will of a people. It also mirrors their history. Account therefore needs to be taken of it as a landmark in a people's set for progress. It contains within it their aspirations and their hopes for a better and a fuller life. Remember, he mentioned again in this case that the Constitution has its letter of the law. Equally, the Constitution has its spirit. It is the fountainhead for the authority which each of the three arms of government possesses and exercises. It is a source of strength. It is a source of what? Power. You see, it says that it has its letter and equally it has its spirit. It doesn't end there, he continues. That its language must therefore be considered as if it were a living organism capable of growth and development, and that indeed it is a living organism capable of growth and development, as the body politic of Ghana itself is capable of growth and development. A broad and liberal spirit is therefore required for its interpretation. So you see, in this case of for an Attorney General, clearly if you have to explain the broad definition of a constitution, this case will be extremely helpful to you because it tells you about the letter and also the spirit. Another case we can rely on to explain the spirit of the constitution is the case of New Patriotic Party versus Attorney General, the 31st December case. You remember in this case the action was brought seeking to declare the 31st December celebration as a national holiday with state funds. An action was brought to declare that intended celebration as being unconstitutional in that it was alleged that it was in conflict with the letter and spirit of the Constitution. Definitely the court relied on the spirit of the Constitution in this case to come to the conclusion that the intended celebration of 31st December as a national holiday with state funds was indeed unconstitutional. So, you see, you can rely on New Patriotic Party and Attorney General to also explain the spirit of the Constitution, and that would also lean in favor of the broad definition of the Constitution. But to show scholarship, don't forget that in this case of New Patriotic Party and Attorney General, there were 5 judges that voted for the majority, 4 voted for the minority. In fact, one of the judges even thought that there was nothing called spirit of the Constitution that he would have to apply over here. Arthur CJ. This is what Arthur CJ said, and as you can see, and I quote his words, "I have found it unnecessary to dive and delve further into what is meant by spirit of the Constitution, because I am convinced that it is a cliche used in certain foreign countries when interpreting their own constitutions, which were drafted to suit their own circumstances and political thoughts." And he adds, and for purpose of emphasis, whether the word spirit is a metaphysical or a transcendental concept, I wish to refrain from relying on it, as it may lead to a conscience of frustration. I would rather rely on the letter and intendment of the Constitution, 1992. So you see, even though I have mentioned that this case of New Patriotic Party and Attorney General can help you explain the spirit of the Constitution, you must be mindful of the fact that one of the judges that voted for the minority, Arthur CJ, actually discounted the relevance or spirit of the Constitution as far as this case is concerned. So he decided to go according to the letter of the Constitution. But remember, the majority relied on the spirit to come to the conclusion that the intended celebration of 31st December as a national holiday with state funds was indeed unconstitutional. As far as the broad definition is concerned, I always like to also refer to the case of Frank Agyechum versus Attorney General and Bright Akwete. Remember in this case when there was a controversy about whether there ought to be a prima facie establishment before you remove the Chief Justice, because the Article 146 did not expressly provide that when you are removing a Chief Justice from office, there has to be the establishment of a prima facie case. Remember, the court actually mentioned, when you read the dictum of the courts, and I'm reading over here for you to see, it says that it has to be remembered that there is room for the unwritten in a written constitution. The fact that a country has a written constitution does not mean that only its letter may be interpreted. the court have the responsibility for distilling the spirit of the Constitution from its underlying philosophy, core values, basic structure, the history and nature of the country's legal and political systems, etc., in order to determine what implicit provisions flow inexorably from the spirit. What implicit provisions flow inexorably from the spirit. So you see, what I'm saying is that as far as introduction to constitutional law and constitutions is concerned, don't forget the broad and narrow definition of constitutions that have been given by Munro, that we have the broad definition and we have the narrow definition. I have gone through these cases that you see on the outline, Tufo and Attorney General, 31st December case, all to explain the broad definition of a constitution. So you have Tufo and Attorney General, you have 31st December case, and you have Frank Ajietum and Attorney General. Still on the first topic, before we move on to the second one, it is important that we actually distinguish the distinction between municipal law and international law, and where does that Ghana stand. Definitely, for anybody that has studied constitutional law, you would have come across the distinction between international law and municipal law. You would have heard that on the international plane, we have two theories. We have the monism theory and you have the dualism theory. I'm sure by now you remember that Ghana is a dualist state by virtue of Article 75 of the 1992 Constitution of Ghana. So Article 75 of the 1992 Constitution of Ghana provides, as you can see, that a president may execute or cause to be executed treaties, agreements, or conventions in the name of Ghana. That a treaty, agreement, or convention executed by or under the authority of the president shall be subject to ratification by A, an act of parliament, or B, by a resolution of parliament supported by the vote of more than one half of all members of parliament. So under Article 75 clause 2, we have been told that a treaty or convention may be executed by or under the authority of the president, but that treaty has to be ratified by an act of parliament or by a resolution of parliament supported by the votes of more than one half of all members of parliament. And this is where you have to be very alert on. In fact, there are many students that have come to the conclusion that the mere fact that a treaty has been ratified according to one of the two modes envisaged by Article 75 clause 2, then it means that the treaty will be enforceable before the court in Ghana. So Article 75 definitely recognizes that Ghana is a dualist state, but there are many people that have formed the impression that the mere fact that a treaty has been ratified according to Article 75 clause 2, either by an act of parliament or by a resolution of parliament supported by the vote of more than one half of all members of parliament, then it means that the treaty is supposed to be enforceable before the Ghanaian courts. However, that would not be the case. In fact, it will seem that that is not the case. If we look at this case of Republic versus High Court Commercial Division, Accra, ex parte Attorney General, NML Capital Limited, and Republic of Argentina interested parties. Please note, this decision is dated 20th June 2013. And now you remember the question I posed, that would it mean that the mere fact that a treaty has been ratified according to one of the two modes envisaged by Article 75 clause 2, then automatically it will mean that it has become enforceable before the court in Ghana or not? This is the case of Republic versus the High Court Accra, ex parte Attorney General, Republic of Argentina, and NML Capital Limited interested parties. Now, the decision was given by Dateba JSC, speaking for the Supreme Court. And these are the words of Dateba JSC in this particular case. After quoting Article 75 of the Constitution, he continues as follows, and I quote, "The mere fact that a treaty has been ratified by Parliament through one of the two modes indicated above does not of itself mean that it is incorporated into Ghanaian law. The mere fact that a treaty has been ratified by Parliament through one of the two modes indicated above does not of itself mean that it is incorporated into Ghanaian law. A treaty may come into force and regulate rights and obligations of the state on the international plane without changing rights and obligations under municipal law. And then he continues, where the mode of ratification adopted is through an act of parliament, that act may incorporate the treaty by appropriate language into the municipal law of Ghana. Where the mode of ratification adopted is through an act of parliament, the act may incorporate the treaty by appropriate language into the municipal law of Ghana. I want you to pay attention to this language, that where the mode of ratification is through an act of parliament, then that act may incorporate the treaty by appropriate language into the municipal law of Ghana. It means that if the mode of ratification is through an act of parliament, but that act of parliament does not incorporate the treaty, then it is possible the court in Ghana may not enforce it. So you can see that he continues as follows, that the need for legislative incorporation of treaty provisions into municipal law before domestic courts can apply those provisions is reflective of the dualist stance of the Commonwealth common law courts and backed by a long string of authorities. The need for legislative incorporation of treaties into municipal law. So he indicates that before they are going to be enforceable, there has to be a legislative incorporation of the treaty into municipal law before the domestic courts can apply those provisions. So don't forget his words over here, that the mere fact that a treaty has been ratified by Parliament through one of the two modes indicated above does not of itself mean that it is incorporated into Ghanaian law. What is relevant is that there has to be some form of legislative incorporation of the treaty into domestic law before they may become what? Enforceable before the courts. So you see, what we have had to do is to just explain the dualist theory and how that differs from the monist theory. For the monist theory, what they believe is that once a law is passed on the international plane, then it's supposed to have effect in the countries straight away, even when there's no ratification. So that is the monist theory. But the dualist theory, and when the dualist theory, an example is Ghana. That the dualist theory, Ghana, for example, we go by the dualist theory. That for the dualist theory, even when a treaty has been passed, there is the need for it to be ratified and domesticated under the laws of Ghana. So that's why you see over here that, however, treaties, even when the particular treaty has been ratified by Parliament, they do not alter municipal law until they are incorporated into Ghanaian law by appropriate legislation. So please note that many people believe that once there is a ratification according to Article 75, then automatically the laws of Ghana can apply it, but that is not enough. Because as you can see over here, you've been told that, however, treaties, even when a particular treaty has been ratified by Parliament, do not alter municipal law until they are incorporated into Ghanaian law by appropriate legislation. Remember this case of Republic versus the High Court Accra, ex-parte Attorney General, NMO Capital Limited, and Republic of Argentina interested parties. There are a number of other cases that you need to take note of as far as Article 75 is concerned. One is that you need to know the case of Banful, B-A-N-F-U-L, Banful and another versus Attorney General. I'm sure those of you remember when President Mahama actually brought in the prisoners from Guantanamo Bay, and then this was an agreement with the US people, but it didn't come to Parliament for ratification. That issue came before the Supreme Court, and the Supreme Court held there's no way you have to bring it to Parliament, and they gave the president 3 months to even do the needful to comply with the Constitution. Margaret Banford, an Attorney General, you need to know this case. Remember also the case of Ndebugri, Ndebugre, Ndebugre versus Attorney General. Also over here deals with Article 75 of the Constitution. And if you want to read from the text writers, remember Professor Raymond Atugube's book. Remember to take a look at page 183, 184, 185, and 186. So 184, 183 all the way to 187. You see these over there in Professor Raymond Atugube's book. Just 4 pages, you get everything over there. And if you read Sir Kofi Kumado's book, look at page 34 all the way to 38. You will see that's over there. Don't forget that Ghana is a dualist state, but the mere fact of ratification, according to Article 75, will not be enough. To make it enforceable before the court in Ghana, don't forget this case of Republic versus the High Court Accra, ex-parte Attorney General, NMO Capital Limited, and Republic of Argentina interested parties. The next topic for us to discuss is constitutionalism. Now, the main points that you need to remember about constitutionalism is the understanding of what the theory even means. When we say constitutionalism, what do we mean? Now, you first have to go to the text writers. When you go through the text writers, the meaning of constitutionalism that you see is simple. That there must be government according to predetermined limitations. In other words, before the government would even exercise some form of power, there should be some restraints placed on the exercise of those particular powers. And it is believed that it is only when there are restraints which are enforceable in the court of law, that is when the government will be properly limited. So you see, for constitutionalism, all that we have to understand is that it is government according to predetermined limitations, that before you exercise some form of governmental power, there should be some restraint placed on the governmental power before you can even exercise it. When you go to the text writers, you go to Professor Kumado's book, you look at page 15. This is what he says over there about constitutionalism. That constitutionalism means government according to predetermined rules which restrain or limit governmental activity. So, predetermined rules that restrain or limit governmental activity. You will see this on page 15 of his book. And he also adds that for constitutionalism to prevail, these rules putting the restraints on governmental activity must be made legal. These rules must be made legal. And if you are using Professor Raymond Atugube's book as well, take note of page 14 and 15, where he says that the constitutionalism, that the concept constitutionalism refers basically to limited government, thus implying that government's decision making should be founded on and guided by predetermined rules. So you see, from the text writers, you understand that constitutionalism means that before you exercise some governmental power, there should be some predetermined limitations. Remember, when you read Professor Raymond Atugube's book as well, on page 15, these limitations have been placed under three different headings. That they can be institutional limitations, they can be substantive limitations, or they can be procedural limitations. So remember, constitutionalism means government according to predetermined limitations, and these limitations can be in three forms: procedural, substantive, and institutional limitations. What do we mean by institutional limitations? Institutional limitations basically refers to one institution serving as a check on the other institution, and it manifests in the form of separation of powers. So for example, under Article 78, you see an example of an institutional limitation over there, in the sense that under Article 78, if the president appoints his ministers, they have to be taken to parliament for prior approval. If parliament does not approve of them, they cannot even become ministers under Article 78 of the Constitution. Remember over here the case of J.H. Mensah and Attorney General. Remember under Article 71 of the Constitution, when it comes to the salaries payable to the members of the judiciary, they are determined by the executive and approved by Parliament. That shows a check on the judiciary, that their salaries have to be what? Approved. They have to be determined by the executive and approved by Parliament. That shows how institutions are serving as a check on other institutions. And check Article 71 1A, you will see this over there. Remember again that also under the constitutional framework we have in Ghana, under Article 106, you are not allowed to introduce a bill affecting chieftaincy to Parliament without prior reference to the National House of Chiefs. You can't introduce a bill affecting chieftaincy to Parliament without prior reference to the National House of Chiefs. So it means that is showing that the National House of Chiefs is serving as an institutional limitation on the powers of what? Parliament. So institutional limitation means that there are instances whereby one institution may serve as a check on the other. Then when you get to procedural limitation, what it means that there are step-by-step procedures that you have to follow if you are exercising some constitutionally sanctioned authority. So an example is that under Article 106, before a bill will become law, after the bill has been passed by Parliament, it has to be assented to by the President. That is a procedural limitation. Again, under Article 78, if you have to appoint your ministers, procedurally, you have to appoint majority of your ministers from Parliament, and they have to go through the prior approval of Parliament. That is a procedural limitation. Again, under Article 146, if you have to remove a justice of the Superior Court from office, there is a procedural limitation over there that you have to go through. Over there, remember the case of Frank Agyechum and Attorney General. Also remember Ghana Bar Association and Attorney General. You remember Agyechum when the court had to hold that procedurally, if you are going to remove the Chief Justice, there will necessarily have to be the establishment of a prima facie case. And in GBA and Attorney General, to remove the Chief Justice, the court held that it does not have to come under Article 2 of the Constitution. You either have to go under Article 146. They are all affirming procedural limitation. And for substantive limitations, I would always indicate that they come in the form of prohibitions or mandatory injunctions. So they are telling that you cannot do this. An example, Article 3, Clause 1, substantive limitation. You can't pass any law making Ghana a one-party state. Under Article 170, and Article 17, Clause 4D as well. Under Article 17, Clause 4D also, Parliament is enjoined not to pass laws inconsistent with the spirit of the Constitution. In fact, under Article 1, Clause 2, any law found to be inconsistent with any provision of the Constitution will, to the extent of the inconsistency, be deemed to be null and void. All of these are manifestations of substantive limitations. So for constitutionalism, just remember the definition. Government according to predetermined limitations. Remember the different types of the limitations. Procedural, substantive, and institutional. And give examples for each of them, and then you'll be done with constitutionalism. So when you take a look at the course outline, there are a number of cases over here under constitutionalism. You can see J.H. Mensah, Attorney General. This case goes to affirm procedural limitations that before you exercise some governmental power, there should be some lay-down procedures you have to what? Go through. If you are going to appoint your ministers, go through this procedure. Remember again also under Tufon Attorney General, if you do anything which is in conflict with the Constitution, it will be deemed to be null and void. Remember in the case of MPP and IGP, in this particular case as well, it shows how the court could check actions taken by the legislature, because this was a public order decree which was declared to be unconstitutional. It goes to affirm the substantive limitations and also institutional limitations, because you have the judiciary checking another organ of what? Government. Again, in the 33rd December case, New Patriotic Party and Attorney General, 33rd December case, this case also goes to show the substantive limitations, that you dare not pass any law that would lead anybody to allow someone to declare 31st December as a national holiday, because it was in conflict with the letter and spirit of the Constitution. So that case will also go for both substantive limitation and institutional limitation. Institutional because we saw the judiciary checking actions taken by the executive and legislature, and substantive also because what they were doing, it was in conflict with the Constitution, so it could be declared to be null and then what? Void. Remember Agyechum and Attorney General. Remember in this case, procedurally, we could see how the court held, procedurally, we could see how the court held that if you want to remove the Chief Justice from office, you necessarily have to establish a prima facie case as a requirement you have to go through before you remove the person from office. In fact, they didn't even end over there. They also added that the entire process must be held in camera. So you see, this case also affirms procedural limitations. Agyechum and Attorney General and Bright Akwete, Wari and Oforiatta. You remember Wari and Oforiatta? Wari and Oforiatta affirms the position that before you introduce a bill affecting chieftaincy to Parliament, there must have been some prior reference to the National House of Chiefs. So this is showing procedural limitation first of all, that before you introduce a bill affecting chieftaincy, there should be some prior reference of the bill to the National House of Chiefs. That is Wari and Oforiatta. And that case can also serve as an institutional limitation, because one institution is serving as a check on the executive and parliament as far as introducing a bill affecting chieftaincy is concerned. We also have Shalabi and Attorney General. In this case, if you read this, when the executive was taking steps to use legislation to deprive people of their citizenship, the court held that they could not have taken those steps to deprive the people of their citizenship. That case goes to affirm both substantive limitation that you cannot do this and also procedural limitation. If you want to do it, you must go through the right way. It may also cut across for institutional limitation because the court was checking another organ of government. So all I'm saying about constitutionalism is that there is government according to predetermined limitations. The limitations can be in three forms. They can be procedural, they can be substantive, and they can be institutional. The cases and the articles of the Constitution will let you know that institutional, one institution serving as a check on another institution. Procedural, before you exercise the power, follow this laid down procedure. And then also, as far as substantive is concerned, it comes in the form of prohibitions or substantive injunctions. You cannot do this or you must do this. That counts for the substantive limitations. Next topic to be discussed is separation of powers and then checks and balances. Separation of powers and checks and balances. Now, the simplest way to view this topic is to understand that this topic, the starting point is to begin from what the theorists have said about separation of powers. And for the theorists, your best bet is to go to John Locke. John Locke in his book, The Second Treatise of Civil Government. John Locke in his book, The Second Treatise of Civil Government, and Baron de Montesquieu in his book, The Spirit of the Law. So these two persons actually gave their own expositions on what they believe separation of powers is. So you will notice that John Locke actually mentioned that it will be too great a temptation that the same people who make the laws should have the power to implement those particular laws. So John Locke mentioned that it will be too great a temptation to allow the very people that make the laws to be the very people who would implement it. If you're not careful, they would exempt themselves from the laws that they end up passing. John Locke said this in his book, The Second Treatise of Civil Government. Remember that, so from what John Locke said, it looks like the focus is a lot on the legislature and the executive. But Baron de Montesquieu, in his book, The Spirit of the Laws, he also indicated that it will be too great a temptation, it will be too dangerous that you allow the three organs of government, one person to exercise the powers given to the three organs of government. You see? So definitely, if we take a look at what Montesquieu is saying and what John Locke is saying, Montesquieu in his book, The Spirit of the Laws, and John Locke, The Second Treatise. The treatise is spelled Treatise, the Second Treatise of Civil Government. They all come to the conclusion that it's going to be too dangerous to put all the governmental power into just one particular person that would have to exercise. So when you combine the views of John Locke and Montesquieu, separation of powers can mean one of three things. You can have institutional separation, which means that one institution should not control or intervene in the work of another institution of government. So, for example, the executive don't intervene in the functions of another organ of government. It could also mean functional separation, which means that one institution or one branch should not exercise the functions of another organ of government. So, for example, ministers should not have judicial power. And it can also mean separation in terms of personnel, which means that one person should not belong to more than one organ of government. So, separation of powers, to lay down a good foundation, you can go to the theories, Baron de Montesquieu in his book, The Spirit of the Laws, and John Locke, The Second Treatise of Civil Government. Remember that when you combine the two, and what the scholars have written, separation of powers can mean one of three things: institutional separation, functional separation, and then separation in terms of personnel. Next is to quickly discuss how has the concept been applied in the US, so in foreign countries. So usually in the UK, I would use the case of Blackburn and Attorney General. And I'll remind you that in Blackburn and Attorney General, the whole case that you can relate to separation of powers is that the court held that the power to enter into treaties was something that was reserved for the crown, and therefore the court will not intervene when the crown is exercising the power to enter into treaties. This is because of the treaty that we're going to sign that Blackburn was challenging, that is something that would not work in the interest of the United Kingdom. The court held that, you know what, when it comes to signing treaties, it is something reserved for the crown and not the courts. So they will not interfere in those particular functions. So even though the court never expressly mentions separation of powers, this statement clearly indicates that we are affirming separation of what? Powers. And then if it gets also to the USA, the case that would be the best case to use as far as separation of powers is concerned in the USA is the case of Youngstown Tube and Company versus Sawyer. Youngstown Tube and Company versus Sawyer. This is what is referred to as the steel seizure case. Steel seizure case. Youngstown Tube and Company versus Sawyer. That's the American steel seizure case. That case, remember the dictum of two judges. Remember Justice Black and Justice Jackson. Justice Black is the one who advocated for the strict type of separation of powers, that it must operate in the watertight compartment. But Justice Jackson is the one that took the position that no way, there should be some interdependence as far as how the organs of governments carry out their functions. Now, while they should be separate, they should also be what? Interdependent. While they should be separate, there should be some reciprocity in terms of how they carry out their functions. So the bottom line is that for separation of powers, they are the theorists. We have Baron de Montesquieu, Spirit of the Laws, and John Locke, the second treatise of civil government. And then when you get further down and you come to the different types of separation of powers, you have functional separation, institutional, and separation in terms of personnel. But how has it been applied in foreign countries? UK, we have Blackburn and Attorney General. In the US, you have Youngstown Tube and Co. versus Sawyer. Remember, in the US, Justice Black, in this case, went for the watertight compartment of separation of powers. But Justice Jackson went for the flexible type that advocates more for checks and balances. That while they are separate, they should also be what? Interdependent. In the US also, Marbury and Madison has actually explained separation of what? Powers. So let's see the Ghanaian cases, and let's see how the Ghanaian cases have also applied separation of powers. Usually I'll start by saying that in Ghana, remember that Article 58 gives executive power to the president, Article 93 gives legislative power to parliament, and Article 93 and Article 125 gives judicial power to the judiciary. That shows that in Ghana we are separating the executive power to different organs of government. So we have these cases over here that have actually explained that. So in Ghana, how have the cases also explained separation of powers in Ghana? I would always begin with Tufo and Attorney General. How do we use Tufo and Attorney General to explain separation of powers? You remember in this case, the action was brought against the Attorney General and the Speaker of Parliament. You remember that the action was brought against Attorney General and Speaker of Parliament. You remember what happened after that happened? In this case of Tufo and Attorney General, when the action was brought and the Speaker of Parliament was added to the suit, you remember what transpired in this case? The court held that they will strike out the Speaker of Parliament as a party to the suit because they can only take judicial notice of what has happened in Parliament and that they cannot inquire into how Parliament went about its business, and that insofar as Parliament acted within the confines of the Constitution, their actions were a closed book and could not be impugned in the courtroom. So by striking out the Speaker of Parliament, by holding that whatever happens in Parliament is a closed book, clearly they were applying separation of what? Powers. So even though you not see separation of powers expressly being mentioned in the case law, that is how you can relate to foreign Attorney General to separation of what? Powers. I believe you can also see that under separation of powers, we also have Ghana Bar Association and Attorney General. You remember this is the case in respect of which the Ghana Bar Association brought an action seeking to impugn the appointment of Aban as Chief Justice. And therefore, the court had to pronounce on whether the court had the power to even overturn the decision taken by the executive. You remember, in this case, the court held that any attempts, and this is the case of Ghana Bar Association and Attorney General, the court held that any attempts by the Supreme Court to claim a power to be able to declare null and void the appointment of the Chief Justice made by the President in consultation with the Council of State and with the approval of Parliament would not only be an absurd and excessive extravagance, but also a usurpation of the constitutional functions of both the executive and legislature, and therefore illegal. It would be a usurpation of the constitutional functions of both the executive and legislature, and therefore to become illegal. You see also over here under the separation of powers that we have Youngstown Tube and Co. versus Sawyer. You remember this case in America where we mentioned that there is Justice Jackson and Justice Black and what they said about separation of powers. Justice Black went for the watertight compartment and Justice Jackson went for the flexible kind of separation of powers. You can see over here as well, we have MPP and Attorney General, 31st December case. Clearly, you know how this relates to separation of powers, because in checks and balances, because it is after there was an attempt to declare 31st December as a national holiday with state funds. That was when the court had to intervene to check the executive and legislature that what you are trying to do is unconstitutional. That amounts to checks and then what? Balances. That we are not applying the strict form of separation of powers. We have the checks and then balances. J.H. Mensah, Attorney General. It shows us also how the court in Ghana, we can have the court, actually the executive checking the what? Legislature. Sorry, the legislature checking the what? Executive. That if you are appointing your ministers, majority must come from parliament and they must take the prior approval of parliament. So that shows how the legislature can check the what? Executive. It's showing checks and then balances. But many people have been asking that in Ghana, is there anywhere in our constitution where we are required or enjoined to practice separation of power? This case of Professor Stephen Kweku Asari and Attorney General would give you the answer to that particular question. Because in this case, you remember this is a case that concerns swearing in of the Speaker of Parliament when the President and the Vice travel out of Ghana. That the practice has been that we will swear in the Speaker of Parliament to act as President. So an action was brought. Remember, Speaker of Parliament is under the legislative arm. President and the Vice, they are under the executive arm. When they travel out of Ghana and you are swearing the Speaker of Parliament, won't it amount to an affront to separation of powers? So Professor Asari brought an action before the Supreme Court, arguing that that practice violates separation of powers and therefore is supposed to be declared unconstitutional. What did the court say as far as that particular statement of law is concerned? Professor Kluge held, amongst some other justices, held that as far as this case is concerned, they will lean in favor of the supremacy of the Constitution. That if you go according to the constitutional text, it allows that when the president and the vice are out of the country, they should be deemed to be unable to perform their functions so that the Speaker of Parliament can be sworn in. Now the real question, wouldn't that violate separation of powers? This is what Professor Kluge said. As you can see over here, and I quote, "Nowhere in this constitution are we enjoined to observe or apply such a doctrine." You see, nowhere in this constitution are we enjoined to observe or practice such a doctrine. It is a goal that may be attained if it is desirable. However, if the need arises, the doctrine must yield to pragmatism and political reality. Therefore, relying on other parts of the Constitution and its principal structure, it is clear that the Constitution envisages that if need be, the Chief Justice, that is the head of the judicial branch, may perform the functions of the President on a temporary basis. And you see what he says over here. If the doctrine of separation of powers must be violated in order to ensure that the office of the President is never to be unperformed and never in abeyance, I would readily violate it to spare the nation anarchy and then chaos. So, in fact, if you read the entire Constitution from beginning to the end, you might not see anywhere that separation of powers to be mentioned at. So what they are saying is that it's a concept which will apply if it is desirable, but if its applicability is going to conflict with the Constitution, then they rather affirm the supremacy of the Constitution and forget about separation of powers. So for separation of powers, remember, define it according to the theorists, show us how it's been applied in the UK, Blackburn and Attorney General, US, Youngstown, Tube and Co. versus Sawyer. Come to Ghana, remember the cases. 2-4 an Attorney General, Speaker of Parliament, strike you out. GBA, court does not want to interfere in the work of the executive. Youngstown, Tube and Co. versus Sawyer, Justice Black and Justice Jackson. Then we also have MPP and AG, 31st December case, checks and balances. We're checking the executive. J.H. Mensah, checks and then what? Balances. And then remember Asari and Attorney General. That reminds us that Professor Kluge, that separation of powers is a concept which will apply if it's desirable. But if its application is going to conflict with the Constitution, we will violate separation of what? Powers. The next topic we have to discuss is rule of law. Rule of law. Now, for rule of law, the simplest way to actually understand this topic is by understanding that this topic actually refers to just the quality of law. The quality of law. So it's not just a matter of the law having been enacted. We are dealing with the quality of law. And so when you read Professor Raymond Atugube's book, for example, page 29, this is what he says, and I quote, "The rule of law is therefore concerned with the values underpinning the Constitution, which translates into the pillars of the Constitution, and which pillars guide the use and exercise of public power. In a formal sense, every society is governed by rules of law, yet it is not every society that lives under the rule of law. As an ideology, the rule of law concerns itself with institutions, processes, rules which allow us to live our lives in peace, security, and dignity." End of quote. So you can see that from Professor Yomona Togube's book, it tells us the rule of law is concerned with the values underpinning the Constitution, which translates into the pillars of the Constitution and which guide the use and exercise of public power. So generally, we are telling you that when you go to the police, when you go to the military, when you go to the fire service and they are dealing with you, how are they exercising their power? That is what will determine whether we have the rule of law applying or not. So rule of law is more concerned with the quality of law. And you see, when you read Sir Kofi Komado's book as well, this is what he says about rule of law, to let you know that for rule of law, we are only referring to the quality of law and not just the mere law that has been enacted. The quality of the law itself. This is what he says. That this usage, that is the rules of law, it draws our attention, and I'm reading from page 19 of Sir Kofi Komado's book. It draws our attention to the quality of the so-called rules of law. It provides us with a yardstick or ideas for measuring good law or bad law. It enables us to separate a constitutional regime from an oppressive or authoritarian one. As Ivor Jennings teaches us, properly understood, this ideological usage refers to principles which are intangible, but which produce a positive and comforting impression on the mind of any observer who crosses from the boundary from a dictatorial state into a free country. What we are saying over here is that for rule of law, we are referring to the quality of the law. It's not just a matter of you having the laws passed on the law books. We are referring to the quality of the law itself that has been passed. Is it a law that is respecting people's fundamental human rights? Is it a law that is actually allowing people to live in peace and harmony? If yes, then we have the rule of law applying. In writing your introduction to an essay on rule of law, you cannot afford to forget A.V. Dicey in his book Introduction to the Study of the Law of the Constitution. A.V. Dicey in his book Introduction to the Study of the Law of the Constitution. A.V. Dicey actually conceptualizes the rule of law into three different headings. He indicates that, first of all, no one should be punished without breaching an established law in a trial before the ordinary court of the land. This refers to supremacy of the law. No one should be punished without breaching an established law in a trial before the ordinary court of the land. This means that there must be supremacy of the law. Number two is that he also indicates that there must be equality before the law. It means that we should not have people that would not be equal before the law. And also there must be some certainty in the law. So crime should be clearly defined. We need to know what the law says. So generally, there have been several authors that have been given their expositions on what the rule of law should be, but you cannot forget the position of A.V. Dicey in his book Introduction to the Study of the Law of the Constitution. Don't forget, rule of law refers to the quality of the law itself and not the law merely having been passed. So the quality of the law, how you determine the quality of it? There should be supremacy of the law, there should be equality before the law should also be certain and predictable. So you have seen the cases on the course outline under rule of law. You see over here, we have a number of cases. What I will do to simplify this topic is to remind you to advert your mind to page 27 of Professor Yomona Togube's book. Then we'll explain the concept vis-a-vis the cases over here. So by the time we're done, you should remember the key things you have over here. First thing is that if you read from page 27 of his book, he indicates that a component of the rule of law is that there should be equality before the law. That is to mean that no man is above the law. You will see this equality before the law having been applied in the case of Nate versus Gatti and Abdurrahman versus Baba Ladi. You remember this case of Nate versus Gatti. This is the case that actually was a reference from the district court to the Supreme Court. You remember this case? This case, the lawyer had commenced a legal action for his legal fees, and then he had not given the 1 month notice that is supposed to be given according to the Legal Profession Act, because by the Legal Profession Act, before you sue for your legal fees, you must give a bill. And then if the person doesn't pay, then you now go and institute the action for your legal fees. So this man did not give the bill, but he went ahead to commence the legal action. Now the other party raised an objection. Then the lawyer says that no, but why is there a discrimination? If other people are suing for their legal fees, they don't have to give any 1 month notice. If I have to give my bill before, that provision is discriminatory. It flouts on the equality principle under Article 17. A reference was therefore made to the Supreme Court so that we interpret what Article 17 now means. What is relevant about this case is that this case teaches us that even though Article 17 says that we must all be equal before the law, it doesn't mean that everybody in Ghana has equal rights. This case makes us realize that there can be lawful discrimination. That the fact that a law discriminates does not mean that it is unlawful. You see, take a look at Article 17, Clause 2. All persons shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status. It means that specific grounds have been mentioned that you cannot discriminate a person on those particular grounds. So Nate and Gatti teaches us that the fact that there is equality of all persons doesn't mean that everybody in Ghana must be equal. It is possible that there could be discrimination because, in fact, the police cannot have the same rights as a student. That is the case of Nate versus Gatti. So remember Nate versus Gatti. That it tells us that the fact that we all have to be equals the fact that there is equality before the law under Article 17 Clause 1A doesn't mean that everybody in Ghana has to be equal. There can be lawful discrimination. Then remember the case of Abdurrahman and Baba Ladi. This case also, the Supreme Court had to pronounce on the Islamic practice that when a person dies without leaving a will, if you are going to distribute the properties, do not treat women to be subordinate to men. Treat everybody to be equals. So if you are familiar with this particular case, this is the case that upheld the position that the Islamic Judicial Committee, that had actually upheld a decision that was distributing property belonging to a deceased person, and they had to give different treatment to the men and different treatment to the women. The court held that that practice was discriminatory, and that once Article 17 provides that we are all equal before the law, men and women of the deceased person, they should all be given equal entitlement. That is Abdurrahman and Baba Ladi. And then you remember Shalabi and Attorney General. Shalabi and Attorney General, the law that had been passed, that's right, to deprive people of their citizenship. So the people were citizens of Ghana, but a law was being passed to deprive them of their citizenship. And the court intervened and held that you cannot deprive people of their citizenship in such a manner. And that citizenship, once it has been conferred, it can only be lost through the procedure that conferred the citizenship. So Shalabi and Attorney General provide that once citizenship has been conferred, it can only be lost through the procedure that conferred the citizenship. It cannot be lost through some form of uncertainty. So when we say the law must be predictable and certain under rule of law, remember Shalabi and Attorney General. Then we have New Patriotic Party versus the Inspector General of Police. Remember, under rule of law, we have supremacy of the law. So this case of New Patriotic Party versus Inspector General of Police tells us that that law that had been passed, that was trying to deprive people of their right to demonstrate. That before you demonstrate, you have to come and seek a permit from the police. That law was in conflict with Article 21 of the Constitution. It means that in this case, we were affirming the supremacy of the Constitution. We will not allow any law to take away that supremacy of that provision of the Constitution. So that is New Patriotic Party and Attorney General. It aligns with rule of law, especially about supremacy. And then still on supremacy of the Constitution, New Patriotic Party and Attorney General, 31st December case. You remember this case. This is a case in respect of which the court upheld the decision that when the state tries to celebrate 31st December as a national holiday with state funds, that practice will be deemed to be unconstitutional. So by saying that it was unconstitutional, they were affirming supremacy of the law. Do you remember, as far as the elements of rule of law is concerned, one of them is that there must be supremacy of the law. So 31st December case helps us understand supremacy of the law. And I'm sure you have also seen this case on the course outline under rule of law. Associated Provincial Picture Houses versus Wednesbury Corporation. Associated Provincial Picture Houses versus Wednesbury Corporation. This case is the case that actually has formed the foundation of the cardinal principle under administrative law. So, and if you are supposed to have the rule of law applying, administrative bodies, they must make sure that the decision that they give, it has to be fair and reasonable. So if you have rule of law applying, all we are saying is that if you're an administrative body, you have the power to exercise some form of discretion. Rule of law requires that the discretion that you exercise, it must be fair and it must be reasonable. So that is also a component of the rule of law, that administrative bodies, they have to act fairly. So there are times when you would hear the Wednesbury principle. The Wednesbury principle. What do you mean by the Wednesbury principle? This is what we mean by the Wednesbury principle. That a person entrusted with discretion, and I'm reading from the case, a person entrusted with a discretion must direct himself properly in law. He must call his own attention to matters which he is bound to consider. He must exclude from his consideration matters which are irrelevant to what he has to consider. So you see, if anybody comes to you and then you have to vest the person for a position, forget about the person's grandmother and what the person's grandmother did to you. Call your attention to only matters which are actually relevant to the reason why the person is before you. That shows that you are acting fairly. So as an administrative body, even though you have a discretion, it doesn't mean you can just do anything that you want. Otherwise, we don't have the rule of law applying. Don't forget, Associated Provincial Picture Houses versus Wednesbury Corporation. So when you keep on hearing the Wednesbury principle, it is from this case of Associated Provincial Picture Houses versus Wednesbury Corporation. And then we also have, I'm sure you've seen this case over here, Council of Civil Service Unions versus Minister for the Civil Service. Council of Civil Service Unions versus the Minister for Civil Service. How does this case also align with rule of law? This case also, you have to read it because it governs administrative bodies. That when an administrative body or a person that has the right to exercise some discretion, he is supposed to exercise that discretion. This case lays down the position that that discretionary power, you have to make sure that the decision that you pass, it has to be legal, it has to be rational, it has to be procedurally proper. So if you give a decision which is illegal, which is irrational, which is not procedurally proper, then it will be a basis for us to even challenge that decision that it was not in consonance with law. So when you see this case, Council of Civil Service Unions versus the Minister for the Civil Service, is drawing your attention of the three heads under which you can challenge an administrative action. That if you give an administrative decision, you have to make sure it is not illegal, it is not irrational, it is not procedurally improper. That is also under the rule of law. And when you go through this case of Council of Civil Service Unions versus the Minister for the Civil Service, don't forget Lord Diplock's position about what he means by legitimate expectations. So all I'm saying about rule of law is this. Rule of law, you know what it means from A.V. Dicey in his book, The Study, Introduction to the Study of the Law of the Constitution. You have your various components over there about supremacy, equality, predictability, and certainty. When you go under those ones, don't forget how you can use the cases over here to relate to the rule of law. We have Nate and Gati about equality, Abdulrahman and Babaladi also about equality. We have the case of Shalabi and Attorney General about supremacy and certainty and predictability of the law, New Patriotic Party and Attorney General about supremacy of the law, and all other cases over here. That is what we can say about rule of law. But don't forget, rule of law, according to the theories, refers to the quality of the law itself and not just you passing the law on the law books. Thank you. The next topic we have to deal with is judicial review and judicial independence. So judicial review and judicial independence. For judicial review, the simplest way to understand judicial review is to understand it from the perspective of what Raymond Atuguba has said on page 29 of his book. In fact, this statement, the moment you capture it, the entire judicial review will come and appear to you in a very good perspective. In fact, this is what he says on page 29 of his book. Judicial review, in the sense in which it is used in Ghana, refers to the double-pronged concept that conveys the power of the judiciary to invalidate legislation and executive actions on the grounds of unconstitutionality on the one hand, and the power to determine the legality of administrative action on the other. End of quote. So you see, so for judicial review, two things: the power of the judiciary to invalidate legislative action or executive action on grounds of unconstitutionality on the one hand, and then also the power to review administrative action on the other. That is all you need to know under judicial review. So, for example, under Article 2 and Article 130 of our Constitution, the Supreme Court is given the power to review actions taken by other organs of government. That is judicial review on the one hand, because that shows you reviewing legislative or executive action on the one hand. And you see, any essay you write on judicial review must recognize the imports of Marbury and Madison as far as judicial review is concerned. Because Chief Justice Marshall, when he delivered the locus classicus of judicial review in Marbury and Madison in America, he clearly stated, in fact, that it has been credited as the beginning of judicial review in America, that laws can be declared to be unconstitutional by the judiciary when they conflict with the Constitution. So Chief Justice Marshall actually set the ball rolling in America as far as judicial review is concerned, that when laws are found to be in conflict with the US Constitution, then they will be declared to be unconstitutional. So in Ghana, if you look at the course outline, how can we release these cases to judicial review? Remember, judicial review, we have judicial reviewing actions taken by the executive or the legislature on the one hand, and then we also have reviewing actions taken by administrative bodies. Your course outline: New Patriotic Party versus the Inspector General of Police. You remember this case is about the right to demonstrate. This is the case in respect of which the Supreme Court declared as unconstitutional that law in the Public Order Decree that required that you have to seek a permit before you embark on a demonstration. So since the Supreme Court intervened, the judiciary intervened to declare an action taken by the legislative arm as unconstitutional, that amounts to judicial review. And if you look at 31st December case, you remember New Patriotic Party versus the Attorney General, 31st December case. This is a case in respect of which the Public Holidays Law and the executive, they allowed people to declare 31st December as a national holiday with state funds. And the court had to intervene in this case to declare that the intended celebration of 31st December as a national holiday with state funds, it was in conflict with the Constitution. It was in conflict with Article 3, Article 35 and 41. It was in conflict with them, and therefore they declared it to be unconstitutional. This is a classical case of the Supreme Court reviewing actions taken by the executive and legislature. If you also remember this case of New Patriotic Party and Attorney General, the SEMA case, which you have on the outline. In this case also, there was the Council of Indigenous Business Associations law, and an argument was raised that provisions in the law were in conflict with Article 21, that guarantees freedom of association, and Article 37 Clause 2A, that also guarantees freedom of association. And the court indeed agreed and held that the provision in the Council for Indigenous Business Associations law that infringed on that freedom of association, it was held to be unconstitutional. Clearly, therefore, the Supreme Court again was interfering to review actions taken by another organ of government. That shows judicial review. So you see over here also, you have the case of Ajiechum and Attorney General and Bedakwete. You remember in this case, an action was brought under Article 146 to impeach the Chief Justice. And if you go according to the literal meaning of the Constitution, if you are removing the Chief Justice from office, once the President receives the petition, he has to go ahead and form the committee that will hear the probe. In other words, there was no requirement of the establishment of any prima facie case if you have to remove the Chief Justice from office. So the President took steps to form the committee, and Ajiechum found an action in the Supreme Court, arguing that no way, even if you want to impeach the Chief Justice, even though the Constitution doesn't state expressly that there must be a prima facie case requirement, you still have to establish a prima facie case before you form the committee that will hear the basis for the removal of the Chief Justice. So you see, in this instance, the court agreed and held that yes, if you want to remove the Chief Justice, there should still be the requirement that a prima facie case is supposed to have been what? Established. So in this sense, the court was being invited to review an action taken by the executive since they had gone ahead to form the committee. That is how you can relate Judicial and Attorney General to judicial review. Because remember, when you read Professor Raymond Asugube's book on page 29, he said judicial review can include judicial reviewing executive action. So in Judicial, if executive has gone ahead to form a committee and is being checked by the judiciary, that amounts to judicial review. And you are seeing over here as well, you can see over here as well the case of J.H. Mensah and Attorney General. Clearly, in J.H. Mensah and Attorney General, this was a case in respect of which the president had refused to submit some of his ministers to parliament for prior approval. And the court held in this case that that refusal will be unconstitutional. If it were to be unconstitutional, who is checking who? The judiciary is reviewing actions taken by the what? Executive. To for an Attorney General, you remember when an action had to be commenced against the Attorney General to ensure that Apalu will still be a what? A Chief Justice of the Republic of Ghana. The court had the action and held that Apalu still had to be the Chief Justice of the Republic of Ghana. That shows how the judiciary was reviewing actions taken by what? The legislature and even the executive. Because remember, to for an Attorney General, Apalu had gone to Parliament for prior approval and they have kicked him out, that they don't approve of him. So the Supreme Court was invited to review an action taken by the what? The legislature. So if you want to understand judicial review, like I said, the simplest way to put it is from the perspective of what you have from Professor Raymond Atugube's book. If you read page 29, that the power of the judiciary to review actions taken by the executive and legislature on the one hand, and reviewing administrative actions on the other. What I have done so far is to take you through the reviewing of actions taken by the executive and legislature on the one hand. We've gone over Marbury and Madison, which shows from America that Chief Justice Marshall laid down the ground rule for judicial review in America, that once any action is in conflict with the Constitution, judiciary can declare it as such. New Patriotic Party and IGP, remember that the court intervened to review an action taken by the legislative organ of government. 31st December case, they had to intervene to review actions taken by the executive and legislature. Judicial and Attorney General, they had to intervene to review actions taken by the executive. New Patriotic Party and Attorney General, the SIBA case also, they had to intervene to review actions taken by the legislative organ of government. And we have J.H. Mensah and Attorney General also, when they had to intervene to review an action taken by the executive. You have seen this case here. Consolidated suit of Elikplim Agbemava, Alfred Tuya Yebua, Nana Asante Bedi Atu versus Attorney General. If you've forgotten this case, this is the case that arose after some persons had been convicted of contempt of court, and then the president had to grant those people pardon, that let us grant them a prerogative of mercy. So they had to grant them pardon. And after they granted them pardon, even though they have been convicted, an action was brought before the Supreme Court trying to review the decision taken by the president that you cannot grant these people pardon because they were convicted of contempt of court. In essence, the action was brought to review the actions of the president taken under Article 72 of the Constitution. And what did the court hold? The court held that yes, even though it was contempt of court that led to their conviction, the president had the power under Article 72 to still grant them a prerogative of mercy. That shows that an attempt was made to review an action taken by the executive, but the court held that that particular instance, they could not overturn whatever the executive had done. This is an overview of judicial review of legislative and executive action. But you remember I had already mentioned that for judicial review, it also includes judicial review of administrative action. So for administrative action, you remember under Article 141 of the Constitution. Under Article 141 of the Constitution, you remember that the High Court has been given supervisory jurisdiction over all lower courts and any lower adjudicating authority. So you see over here, if a lower adjudicating authority takes any step which you think that flouts administrative principles, you can actually challenge it under Article 141 of the Constitution. That when I appear before this vetting committee, they did something that flouts my right of what? My right to be heard. I can challenge it under Article 141. And remember that under Article 23, administrative bodies have been given a responsibility to act fairly and reasonably and in accordance with law. So if they do anything that you think that is in conflict with these rights that you have, under judicial review of administrative action, you can trigger an action under Article 141 and tell the court that whatever this administrative body had done, it flouts Article 23, and therefore you want to what? Quash it. So Article 141 gave the High Court the power to review actions taken by lower adjudicating bodies. But don't forget also that apart from the High Court that has the power to review actions taken by lower adjudicating bodies, there's Article 132 of the 1992 Constitution that gave the supervisory jurisdiction also to the Supreme Court on any adjudicating authority. What you must make sure that you understand before you move on is that under Article 132, Supreme Court has supervisory jurisdiction over all courts and any adjudicating authority. Emphasis on any adjudicating authority. But when you come to Article 141, remember you've been told that the High Court has supervisory jurisdiction over all lower courts and lower adjudicating authority. So Article 132, 141, all on supervisory jurisdiction. One says that supervisory jurisdiction over all lower courts and adjudicating authorities. And 132 says any adjudicating authority. Make sure you understand the distinction before you'll be able to say that you fully understand judicial review of administrative action. At least if you want to know the basis on which you can challenge administrative action, I have given you Article 23. Remember also, when we dealt with rule of law, we've gone over the Wednesday principle that shows you the obligation placed on administrative bodies and what they have to comply with. Those are indicators of basis that you can use to challenge actions taken by the administrative bodies. Next is for us to discuss natural justice. And as you are aware, natural justice actually encapsulates two different concepts. We have the rule against bias, which we refer to as the nemo iudex in causa sua rule. And then we also have the audi alteram partem rule, which also means that you have to give the other party the right to be heard. So one of the key authorities that extensively discuss natural justice is this article, which is published in the Review of Ghana Law. When you take a look at this, that is the title published by Daniels. When a judge is not a judge, present trends. When a judge is not a judge. But this article, when you read it, it conducts a very good exposition on the area. But then you must remember that we would have to go over rule against bias and then the right to be heard. The rule against bias and then the right to be. Remember that if you are dealing with the rule against bias, what we have consistently said is that when you take a look at the case of Metropolitan Properties Company Limited, Metropolitan Properties Company Limited versus Lamon, that is where we got a statement that justice must be rooted in confidence. And confidence is destroyed when right-minded people go away thinking the judge was biased. Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking that the judge was biased. So for this reason, if you are dealing with the rule against bias, you should know that if a judge has an interest in the case, and that interest could be financial, it could be pecuniary, it could be relational, your relative, whatever the interest that the judge has in the case, that judge must recuse from the case and must not take part in the adjudication of that particular matter. So you can see on your course outline, you have the case of R and Rand. This case tells us that if you have any form of pecuniary interest in the case, however little that pecuniary interest is, you have to recuse from the case. Do the honorable thing by recusing from the case. That is R versus Rand. once you have a pecuniary interest, no matter how small it is, recuse from the case. Because if you participate in the decision-making process, the decision can be challenged as being null and void. This position about pecuniary interest is further supported by the case of Dimes and Grand Junction. Dimes and Grand Junction Canal. This case also tells us that if you have a pecuniary interest, no matter how small it is, if you participate in the decision-making process, it will make the whole decision null and void. In the same vein, if you have any relational interest also, you have to do the honorable thing. Remember, if you have a relative, your cousin comes before you, because of the fact that you have a relational connection with the case, you have to do the honorable thing and recuse. If you participate, the decision will become null and void. But you see, remember, we mentioned that it is not just you alleging that this person has an interest in the case. There is a test of bias that you have to establish. It's not the fact that because you allege that this person is this person's grandmother, this person's grandfather, so it means that he's going to be biased. If you remember this case of Attorney General and Salah, this is the case in respect of which it was alleged that they saw some judges sitting somewhere with some parties of the case, people that had some connection, they were speaking in some strange language, some relatives, and so they were arguing that the judge should recuse from the case. You remember what the court said? That in Ghana, the test of bias is not mere suspicion. It must be a real likelihood of bias. You must prove real likelihood of bias before that judge will have to recuse from that particular case. So if you can't prove the real likelihood of bias, then it means that you will not be able to let the judge recuse himself from that particular case. So Attorney General and Salah lays down the test of bias. That is not mere allegation of bias. It must be real likelihood of bias before the person would have to recuse himself. This same position also was articulated in the case of Republic vs. High Court Denu, ex parte Agbesia Osu number 1 and Agbesia Osu number 2. The test of bias was reiterated over there. That not mere allegation of bias, but it must be real likelihood of bias before the person will have to recuse himself from hearing the case. And so remember, for rule against bias, it is nemo iudes in causa sua. Once you have any interest in the outcome of the case, you have to recuse yourself from hearing the case. Now, the interest you are referring to, it can be financial, it can be relational. If you read R and Rand, once you have any pecuniary interest, you have to recuse. Dimes and Grand Junction Canal, if you have any interest, you have to recuse. But what is the test of bias? If you read ex parte Agbesia Osu number 1 and ex parte Agbesia Osu number 2, these cases demonstrate that it must not be a mere suspicion. It must be a real likelihood of bias. That is what can lead a judge to recuse himself from hearing a particular case. In fact, this is a difficult test to prove the real likelihood of bias. But at least in ex parte Agbesia Osu number 1, you remember this case. The judge that was hearing a matter that was before his court, he had to go to a particular place where the case was supposed to be heard as trying to resolve the matter out of court. He went there. Even though he did not participate in the hearing of that case out of the court trying to resolve it, by virtue of the fact that he has even made the attempt, and he even went out to even dismiss one of the cases without even hearing the party, the court said that this man is likely that he's going to bias in the case. So in ex parte Agbesia Osu number 1, the real likelihood of bias had been established. If you have forgotten, you have to go back and check. Because like I said, it's a very difficult test to establish. So if you have ex parte Agbesia Osu number 1, Republic vs. High Court Denu, ex parte Agbesia Osu the 2nd, number 1. Go and check to find out how, in this case, the real likelihood of bias was established. Remember, Attorney General in Salah also deals with the real likelihood of bias. That case mentioned that's not mere suspicion, but there must be a real likelihood of bias. But you need to be mindful of and about what amounts to bias. You will see on the outline this case of Quist versus Quantrain. Quantrain is Kwantren. In this case, the judge actually had offered that the parties to try and settle the disputes. And he actually asked them to go and see another judge and that they can come and use his services if they so desire. They never came back. When subsequently they filed a fresh action and they came before him, one party said that this judge has tried to offer us the opportunity to settle, so he should recuse himself. He shouldn't be the judge to hear the matter. The court held that a fact that a judge had tried to promote reconciliation between the parties and has failed is not enough to make him improper to hear the case between the parties. So this case laid on the position that if a judge has tried to promote reconciliation between the parties and that reconciliation had failed, it is not enough basis to say the judge should recuse himself from hearing the matter. This is Quist versus Quantering. So yes, Quist and Quantering tells us that it is not just because you merely suspect that the judge is going to be biased. The fact that a judge has promoted reconciliation doesn't mean that if you come back to that same judge, then it means that that judge must recuse himself. Especially on this case when the judge wasn't the one who even sat down to mediate. He asked you to go and try. And when you went, he never heard of you again. You have returned. And now he's supposed to hear the matter. You are saying he should recuse. Quist and Quantering tells us that that will not be a basis of bias. Then we have Kwame Enquiries. Kwame Enquiries is also a very interesting case on natural justice. In this case, Olenu, who was very familiar and had done a lot of cases about Osu Anata's 2 lands. Now, when he was a judge and the matter came before his court, one party said that this judge should recuse because this judge knows a lot of facts about these particular lands. So he should recuse himself. What did the court say? So you are saying that because the judge had a lot of knowledge about Osu Anata's 2 lands, including your family or this land in question, he should recuse himself. What did the court say? If you look at the holding 7, that the court held that the fact that Olenu J, when at the bar, was specially well acquainted with Alatakwata land and the law relating to it, and appeared as counsel in 2 cases involving such matters, did not amount to substantial possibility of bias, since the parties were not these parties, nor the land this land, nor was he previously aware of the facts in the instant case. So you see, if you see a question, when a particular person went at the bar, had done a lot of cases under Osu Anata's 2 lands, now he's a judge. People have come before him. They are thinking that when he was at the bar, he was doing a lot of things in this particular direction. So let us prevent him from being a judge in this case. The court will tell you that since the cases he did at the bar is not the same case, the parties, not the same parties, the fact that he has knowledge or the law about Osu Anata's 2 lands will not be enough reason to let him recuse from hearing the case. But you so remember, this rule of against bias is a rule of monumental import as far as constitutional and administrative law is concerned. So once you have any interest in the outcome of the case, you must recuse yourself from hearing the case. Otherwise, right-minded people will go about thinking that you were actually what? Biased. So once you have any interest in the outcome of the case, please do the honorable thing. Recuse yourself. You are in the high court hearing the matter. You've given a decision. It has come on appeal. You want to be the same judge that will sit on the matter. Please recuse yourself. Don't forget R and Rand. Don't forget Dimes and Grand Junction. Don't forget Espati Agbesia Osu number 1 and number 2. Don't forget Quist and Quantering. Don't forget Kwame and Enquiries, Attorney General and Salah. Now, even though I have said that this rule is very important, this rule has some exceptions. There are some exceptions that even though you can tell that there's a particular person who actually has any interest in the outcome of the case, the court may say that he should still go ahead to give a decision in that particular case. What are some of these exceptions? One is statutory duty. Statutory duty. So if you have an action against the Chief Justice, so if you look at this case of Chachuchi Kata versus the Chief Justice and Attorney General, the action was against the Chief Justice and Attorney General, and there has to be an empanelment of the Supreme Court. So it was argued that because the Chief Justice has an interest in the case, the CJ should not be the one to do the empanelment. Otherwise, the CJ may interfere in the outcome of the case. What did the court say? The court held that, see, the action is against Chief Justice. The people that will hear the case are justices of the Supreme Court. The Chief Justice only has to perform a statutory role to empanel. But after empaneling, the individual judges will deliver the verdict according to their oath of office. The CJ will not be manipulating them. And therefore, even though the CJ has an interest in this case, the statutory responsibility of doing the empanelment, he has to still go ahead and perform the empanelment. That becomes an exception to the rule against bias. Again, also in Agietrum and Attorney General, if you remember, in this case, the petition was against removal of Chief Justice. And the action before the court was that there should be the establishment of a prima facie case. So a petition had been sent by Mr. Bright Akwete, a senior lawyer, to the president to remove the Chief Justice. the president went ahead to just form the committee according to the strict compliance of Article 146. Then an action was brought in the Supreme Court, arguing that no, President, you were wrong in forming the committee straight away. There ought to have been the establishment of a prima facie case. Now think about it. The person at the center of the controversy is the Chief Justice. That person has to be removed from office. The petition has been sent to the President. Now an action is before the court. Who has to do the empanelment? That very Chief Justice. So an objection was raised that the Chief Justice, in empaneling the people, it will appoint people that will be able to interfere with. It may flout natural justice. So the CJ should not perform the empanelment. What did the court say? You see this case of Frank Ajietrum and Attorney General. The court held in this particular case that the judges, they are not malleable clay. The Supreme Court judges, they are not malleable clay in the hands of the Chief Justice. So even though the Chief Justice may empanel them, they will act independently according to their judicial oath. So even though the Chief Justice may have an interest in the case, the performance of the statutory responsibility, he will still have to go ahead and perform it. So you see, if you look at the course outline, for the exceptions, case 1, 2, and 3, Akufo-Addo and Kwashi Aidan, Chatuchikata is the AG and CJ, Ajetum and AG and CJ, they all go for the possession of the law that once it's a statutory responsibility, he has to go ahead and perform it. Another exception is the principle of necessity. You see the necessity having been mentioned in Ajetum also, and also in Bilson and Apalu. So you see, there are times when if we allow you to raise that issue of natural justice, the implication is going to be that if we uphold it, we will not have anybody to perform the role of dispensing with the justice. You are raising an argument about 5 judges, that they are all biased. If we should uphold it, we are going to lead us in a situation whereby there wouldn't be anybody to perform the functions. In the case of Ajetum, if we should have upheld that decision, there wouldn't have been anybody to do the empanelment. So if you read Ajetum, that's why the court held on the doctrine of necessity. If we must violate natural justice, on the principle of necessity, so that justice, there will not be a failure of justice, then we have to violate that principle of what? Necessity. So you can see in Ajetum case, they made reference to it, and they even made reference to Dimes and Grand Junction Canal proprietors, where they also mentioned what necessity as a situation which can be an exception to the Nemo Judas in Quarter-Sua rule. Let me read what was said in Dimes and Grand Junction Canal. Let me read the statement. What did they say? The opinion of the judges delivered by Part B met with the approval of the House of Lords in the case of Ranger and Great Western Railway Company. In the like manner, this present case presents a situation of necessity where the person to exercise the power to constitute the bench hearing the appeal is also a party to the appeal. A person who is supposed to constitute the bench to the hearing of the appeal is also a party to the appeal, and no other may perform for the duties for him. The objection on the ground of natural justice cannot be sustained. No person is there to perform it. So on grounds of necessity, we can even violate natural justice. So we have 2 exceptions so far. We have statutory responsibility, which we saw in Chatuchi Kata versus the AG and CJ, Ajetum and the AG as well. And we've also had the case of Akufo-Addo versus Kwashi Aidan. Remember the second exception, which is what? The doctrine of necessity is also another basis for us to waive natural justice. And the final one is acquiescence. If you read Bilson and Apalu, it tells us that if you are aware that this person is biased, you keep quiet 5 years after the case has been determined. Final day before decision, you are saying you have an objection. We will not allow you because you have slept on your rights. So for natural justice, don't forget, all we are saying is that you must not have an interest in the outcome of the case. That interest can be financial, it can be relational, it can also be any proprietary interest you have. Don't forget Aaron Rand about pecuniary interest. Don't forget Dimes and Grand Junction Canal about pecuniary interest. Don't forget Expert Agbesia Osu number 1 and number 2 about the test of bias, that it must be real likelihood of bias. Don't forget Quest and Quantrain, Kwame and Queno. All of it demonstrates that there must be real likelihood of bias and not mere suspicion. Don't forget Attorney General and Salah, that provides that there must be real likelihood of bias and not mere suspicion. Exceptions. Number 1, statutory responsibility. Don't forget Chatuchi Kata versus the AG and CJ, Ajetum and AG and CJ, Akufo-Addo versus Kwashi Aidan. Don't forget necessity, which you see also in the case of Akufo-Addo and Kwasi Aidan, and you see in Chachukwu Kadam as the AG and CD. And don't forget acquiescence, which you see in Bilson and what? Apalu. This will be the end of the discussion on the rule against bias. But please take notes. Take notes. There appears to be 3 exceptions that you see that a lot of the books have captured: statutory duty, necessity, and acquiescence. But when you read Professor Raymond Atugube's book, I'm referring to the book titled The New Constitutional and Administrative Law of Ghana, page 703. There appears to be an additional exception that he has recognized, and it is public interest. This is what he says, and I quote on page 703. Another crucial exception worth considering is that of public interest. In instances where it would be against the public interest to comply with the rules of natural justice, non-compliance may not be fatal. Non-compliance may not be fatal. So he makes reference to the case of State Bank of Patiala. Patiala is P-A-T-I-A-L-A, and others, versus S.K. Sharma. Sharma is S-H-A-R-M-A. When you read page 703, you will notice that this creates an exception to natural justice, that public interest is one of the bases on which we can violate natural justice. So that gives us 4 exceptions: statutory duty, acquiescence, waiver, and public interest. Thank you. The next part of natural justice we have to look at is audi alteram partem, which is the rule against bias. Audi alteram partem, which is the rule against bias. Now, the main thing that you have to remember about this rule against bias is this: that no matter how accurate that you think that you are as a judge, hear both sides before you can condemn or pass judgment against anybody. This rule has been traced all the way to the Garden of Eden, that even before God, in his omniscient wisdom, the all-knowing God, even before he could pass judgment against Adam, even though it is believed that he already knew what they had done, he asked them first, "What have you done?" And he had to hear from them before he condemned them by passing judgment against them. So yes, the rule against bias is very fundamental. If anybody has any case against you, make sure you hear both sides before you can pass judgments. What kind of bodies should follow this particular principle? Generally, this principle applies to public bodies. It applies to all persons making judicial or quasi-judicial decisions, executive or administrative decisions. So remember, generally it applies to public bodies. It is said to apply to all persons making judicial or quasi-judicial decisions, executive or administrative decisions. They are subject to this particular rule. In Ghana, several cases have come up in this particular light. As you can see on your course outline, there'll be several cases that you see. There's ex parte Bannerman, as you can see on your course outline. There's Nkumsa and Diage Commission. They demonstrate that it has even been held to apply to commissions of inquiry. So you can see on the course outline ex parte Bannerman, and then you also have Nkumsa versus Diage Commission. They have shown that these principles can apply to commissions of inquiry. We also have ex parte Tiwa. Ex parte Tiwa shows that even the Asokore Traditional Council, the chieftaincy bodies, they are also subject to this particular rule. You can't appear before a chieftaincy body and they will condemn you by giving you passing judgment against you without giving you a right to be heard. That will flout natural justice. So ex parte Tiwa, ex parte Bannerman. Ex parte Bannerman for commissions of inquiry, and ex parte Tiwa also shows that even for chieftaincy tribunals also, they are subject to this particular rule. It has been held to also apply to disciplinary bodies. So when you read Rich M. Baldwin, disciplinary bodies. So Rich M. Baldwin demonstrates that if you're a disciplinary body, you must also hear both sides before you can condemn anybody to face judgment. So Rich M. Baldwin also demonstrates that you must hear both sides before you can condemn anybody at all. Then we also have Abuaje versus Ghana Commercial Bank. You remember Abuaje and Ghana Commercial Bank? If you dismiss anybody at all from the workplace without giving the person a right to be heard, that decision can also be quashed as being null and void, and that is Abuaje and Ghana Commercial Bank. Then there's also Awuni and WAEC. Don't forget Awuni and WAEC. Awuni and WAEC, after reviewing the scripts that people had written for the WASI, realized that it may be possible that the people may have cheated. Now, without giving these people a right to be heard, you proceed to cancel their results and you proceed to pass on disciplinary actions against them. The action was challenged. The court held that this rule of right to be heard is very fundamental. That no matter how much you think that you've seen answers to be the same, you have to give them a right to be heard before you can condemn them. So because you didn't give them a right to be heard, the decision was passed as being null and void. So rule against all the ulterior pattern basically means that hear both sides before you can pass your decision. Ex parte Bannerman commissions of inquiry, ex parte Tiwa traditional councils, rage and Bowden disciplinary bodies, Abuaje and Ghana Commercial Bank, and Awuni versus WAEC. What are the requirements or the components of this rule that you must hear both sides? This rule that you must hear both sides. What are the components? 1, the persons that are affected. Inform them of the date, time, and place of hearing. So if the case is coming on Friday, give them advance notice. Don't go and tell them Friday morning that come and appear before us at 9 a.m. If you don't come, we'll dismiss you. That will not be deemed to be adequate notice. So in that instance, if you receive a notice Friday morning at 6 a.m., appear at 7 a.m., and you don't go and terminate your employment, you can challenge it because they didn't give you adequate time to prepare for your case. So that is the component that you need to be represented, and you have to be informed of your time and place of the hearing. You have to be given adequate notice of the time and place. Otherwise, we can quash it by natural justice. And then also, you have to give the person adequate time to prepare for the case. Depending on the complexity, it can be 1 day, 2 days, 3 days, 4 days, 5 days, depending on the complexity. You must give the person access to documents he needs to prove his case. So if there are some documents that are in your custody that the person has to rely on to prove the case, grant him access to those documents. And then also remember, there must be a right to legal representation. So if you want to actually take part in this particular dispute resolution process, allow people to come there with their lawyers. That if you give the person the chance to come to the lawyer, so that the lawyer can come and speak for the person. So give the person the chance to represent himself through a lawyer. But in all of this, remember, if we give you enough notice and you still fail to turn up when a decision is passed against you, that decision will end up being what? Valid. All I'm saying is that, so for all the ulterior pattern, it means that hear both sides before you can pass a decision. And the hear both sides, it doesn't mean that you always have to just hear the person necessarily. If we give you enough notice and you fail to turn up, then it means that the decision cannot be quashed. If also we give you the right to come with your lawyer and you fail to show up, the decision cannot be quashed. So remember the authorities over here. Remember ex parte Bannerman, ex parte Tiwa, Rage and Bowden, Abuaje and Ghana Commercial Bank, and then Awuni versus WAEC. And in all of this, don't forget that once we give you the right to show up and you don't show up, the decision cannot be quashed by Setora. In all of this, don't forget the case of Accra House of Folk Sporting Club versus Ghana Football Association. Accra House of Folk Sporting Club versus Ghana Football Association. In which case the judge, if you read this particular case, Corsa J, held as follows, and I quote, "To me, the law is clear and unambiguous. All judgments, even foreign judgments, of a foreign country which permits condemnation behind the back of a man, when repugnant to this rule of natural justice, cannot be enforced in Ghana. Where, however, a man has been given the opportunity to appear, again, where, however, a man has been given the opportunity to appear and answer charges against him, and he does not avail himself of the opportunity, he cannot be held to plead a breach of this particular rule." All that we are saying is that for natural justice, we must give you a right to be heard. But if you give you the right to be heard and you don't show up, you can't complain about a breach of this particular rule. This will be the end of our discussion on all the ulterior pattern.